Freedom Counsel is nothing without all of you. How do we go about getting people held criminally responsible for their acts? The military is still at risk. Election interference, the medicalization of childhood. These drug dealers like Pfizer and Moderna, we can seize their property. We develop our litigation through conferences like this. It's going to come through communications. It's going to come through conversations. And Freedom Counsel is that conversation.
For information, visit freedomcounsel.org.
I knew as early as February 2020 that I needed to do something.
I recognized that there was a systematic problem and that this was not about hydroxychloroquine, it was something larger.
Fear shut the world down, and people made a lot of money at it as they were killing us.
I was asked to speak at a freedom rally that was set up to discredit my reputation.
Whoever orchestrated this must not have the safety of this nation in mind.
Medicine and politics should be separated. These doctors were handcuffed.
The American public has awakened. We have a new civil rights movement to restore our rights, and we're going to hold them accountable.
It is a natural progression of a man of God or woman of character to see injustice, to seek it out, and then to act upon it.
Do you hear me? We will never lock down again. This is the hill we die on.
Don't miss New American Heroes with attorney Warner Mendenhall and John Davidson, Mondays on BrokenTruth.tv.
You just have to flood a country's public square with enough raw sewage.
And if anybody is lying here, Senator, it is you.
Once they lose trust in their leaders, in mainstream media, in political institutions, in each other, in the possibility of truth, the game's won.
All right, we're gonna have to pull ourselves together though, because we're gonna have to work on getting her ready to go.
It's kind of hard. You're taking my child away from me.
All right. Well, if we can't pull ourselves together, then I'm gonna ask that you start getting her ready.
Sometimes.
All right, ladies and gentlemen, it's another lovely day in Southern California. With me is the wonderful Warner Mendenhall. And today our guest is Connie Reguli?
Reguli.
Connie is an attorney in Tennessee who has an incredible story about the lengths that the prosecutors went to destroy her in Tennessee for fighting for children's rights. Welcome, Connie. Welcome, Warner.
Wow. Thank you. Thank you. Yeah, it's quite a story, too. I never wanted to be the center of this story either. I just wanted to do a good job. You know, I just wanted to defend parents and children and get them out of the system. And, you know, the clip that you showed about Joy's case, she's been communicating with me. She sent me that body cam footage. I am so happy. We're trying to get body cam footage on all CPS workers, but it just is heart-wrenching. And I have actually personally gone to a government kidnapping at 11 o'clock at night and live streamed it back in 2020. And by the morning, there were 2 million views to it, where they took a 4-week-old baby out of a mother's arms. Mm-hmm. So it's horrible. People need to understand how horrible it is.
Well, yeah, Connie, you actually made that video for the clips that went viral, right? For the Joy's case?
Yeah, so Joy sent me the entire body cam, and I watched the whole thing. It's long. It's about 50 minutes long. And it get if you sit and you watch the whole thing, you can really, really, really embrace how that emotional swelling just continues to grow and grow and grow. But I went back through it and I knew that people wouldn't sit and watch 50 minutes. So I clipped out about 4 segments. And one of them is what you see there at the beginning. And in particular, and when I made my TikTok video on it, the lady in the blue shirt, I still shot at her and put her at the end of the TikTok video as well. And then there were a couple clips from inside, in particular, where the social worker intentionally separates the child from the mother, which is another trick they do. And then at the very end, when they're outside and they're taking the child, it's getting dark. It's a little hard to see, but you can hear the wails of joy as they're taking her child and putting him in the car. And in the case that I did in 2020, very similar thing happened. This 4-week-old baby, they accused mother of substance abuse, and they took that baby out of her arms, put it in a CPS worker's car, and she fell to the ground weeping. And I there was nothing else I could do except, and I got the baby home. In that case, I fought, and we did get the baby home. But yeah, that's it. It's.
Well, how long did it take you to get that baby home?
Well, yeah. So in that case, fortunately, we had a grandmother, and this is this doesn't happen very often. So it was a very unusual circumstances. That baby's maternal grandmother was a sociologist who had actually been hired many times by the state of Tennessee in capital murder cases, where she would go to court and testify on behalf of people in prison of the damage of separation between a child and its parent. And she had publications on it. It was a very unusual circumstance. And she came down from Illinois. And even with all of her credentials, they really tried to give her a hard time, but we were able to get the baby placed with her immediately. And then but we made it so mom could be there every day. She just couldn't spend the night, but we fought it for 10 months. And in 10 months, we had put so much pressure on them, they literally non-suited it and didn't even tell us. We had a court date set. We were forcing them to trial, and I was representing the grandmother at that point. But they just walked in and dismissed the whole case. But it took 10 months. But that's fast. That's fast.
Yeah, with Joy's case, just to plug the event, but several of us are going to be there at the courthouse on February 9th, next Monday, because apparently the state is trying to put a termination of parental rights, TPR, on her. And correct me if I'm wrong, but if a parent has a TPR for one child, doesn't it increase the likelihood they'll try to take the other?
Yeah, and every state is a little bit different in the law, but most states have a provision in the law that a prior involuntary termination of parental rights is, in and of itself, even if it were 20 years ago, to terminate the rights of all future children. It's unbelievable. It's really unbelievable. And it's really hard to find good constitutional attorneys. And I have not been able to find an attorney who will fight that at a constitutional level. I brought a lot of constitutional issues and challenges before, but I never had a case that was right on point on that particular statute. It's clearly unconstitutional as written and as applied to anybody. But yeah, that is grounds for termination of all future children.
So in a situation like Joy's, where there's not infinite financial support to pursue litigation, does a limited budget affect the quality of representation that you get as a client, both from your perspective as an attorney? I mean, look, it makes sense. Like, how many people can hire Dershowitz and 6 other attorneys to represent them for an accused murder of an ex-wife like O.J. Simpson? That's a huge, expensive case. I would get it, like, very difficult. So what do you do for families that don't have an infinite budget?
Well, it is a very difficult question. And I worked as a private counsel. I did not do court appointments. So court appointments, again, every state's a little different, but Tennessee is extremely limited on what they're willing to pay for court appointments and extremely limited on what they'll pay for experts. But there is some budget for that. But I mean, I would tell people it's going to take $50,000 to get your child out of state's custody. And many, many, many times people could not pay me the full amount. And many, many, many times I ended up doing a lot of pro bono work. But in a case, I'll just talk about the whole medical kidnap issue, similar to what Joy has.
Real quick though,
Yeah.
hang on, Connie. You said that the state has some funding. Ohio has funding as well. And in fact, I worked when I was a young attorney, worked in that court-appointed system. How much funding would a family expect that would help with an attorney? Is it just a couple grand or what is it?
So you mean at the state level, what they pay?
Yeah, the state level. What are they providing? Because parents have a right, and to counsel in this type of situation. What is available for them?
Well, in Tennessee, it's very limited. It's like $2,500 at $40 an hour. I mean, it's hard. It's hard to even get attorneys to handle that. And yet, I kind of compare it. In Tennessee, they actually call a termination of parental rights the death penalty for parents, right? And I say, if it's the death penalty for parents, you should be paying attorneys in these civil cases what you pay death penalty attorneys in criminals, which can be thousands and thousands of dollars. So unfortunately, I am going to end up pushing that, but that's kind of where we are now.
And I'm sorry I interrupted you. I wanted to clear that point up so people understand. $2,500 in a court case is a drop in the bucket, and it's very hard. And the counselors who are doing it, which I did, they cannot, they have a lot of other obligations, and there's a lot of simple cases, but there's complex cases that are vastly more time consuming for an attorney to get involved with, and $2,500 isn't even going to come close.
Well, and also remember, the state orders parents to pay child support to the state on the children that they put in custody. So that's now a whole additional expense for them to have. But, one of the things that I'm trying to promote, and I'll come back to medical kidnapping, but one of the things I'm trying to promote is parent advocacy. And I have a bill in Congress to try to compel the states to allow to have parents to have non-legal advocates. And it's really just like having advocates in any bureaucratic system, whether it's veterans benefits or disabilities or mental health, they have advocates. They're simply lay people who have a specialized knowledge in that bureaucratic system. And I'm busy training people to do that, but the courts will not let them participate at this level. But I want to turn back to this medical kidnapping issue here, because there are cracks in it, and we have to push on this now what is left is a thin veneer. The space between parents and these child abuse pediatricians is getting thinner and thinner and thinner. And I'll give you a few examples. There's a gentleman in Texas named Roberson, and he was on death row for a shaken baby case from like 25, 30 years ago. And I mean, they had a huge hearing, and not Dr. Drew, I can't think of his name, but one of the TV doctors went and testified on his behalf. And even the detective who had originally tried to prosecute him came and testified on his behalf at the hearing to set aside the death penalty, saying, I have now learned more about, the shaken baby syndrome and how these symptoms could be caused by other issues. So the Roberson case happened. And then in New Jersey, the Neves case in New Jersey, the court appellate opinion, there were some very good attorneys here, because this appellate opinion goes through step by step by step by step how this child abuse pediatrician's opinion was not scientifically sound. And that's a huge crack in the veneer. And then, of course, in Florida, we had the Maya Kowalski case where they sued the hospital for the misdiagnosis. They won. The Court of Appeals set it aside and gave them immunity, which is hopefully going to be appealed to their Supreme Court. But there's this thin crack in the veneer, but it's been extremely hard. I've had these cases 10 years ago. I had a fractured rib case. I interviewed two different doctors for hours and hours and hours. They emailed me all of these opinions and research studies. I had a 4-inch notebook full of these studies. I did a deposition on one that we played for the court, and I brought the other one to court. I put on like 8 hours of medical testimony, and I was able to prevail. But there are not very many attorneys who are going to do that. So there's now.
I'm sorry, I just have questions because, one of the first things is it's hard to find the experts who will even step up and do that. And then the other thing that I've seen, and we deal with a lot of vaccine injured, through the COVID crisis, but also children who've been vaccine injured. And one of the things that I saw happening is that I believe there are some cases in Ohio where the child was actually suffering a vaccine injury and the parent got charged with shaken baby, for example. And so I've seen that happen. And I wonder if you could speak to the vaccine injury issue as well. Have you seen that?
Well, not specifically, but I have no doubt that it's part of it, because what they're finding in these infants, and these they're usually a fragile infant anyway. They're either premature, mother had preeclampsia, there's some type of other complications that have occurred. And, the babies are having brain bleeds, and they're having retinal hemorrhages, and, they're having hemorrhaging, in their lower part of their brain. And those are quintessential vaccine injuries, right? The bleeding is part of the problem. So although nobody will admit their vaccine injuries, and you can't get a doctor to come and testify to a vaccine injury on a case like that, I mean, hopefully that's one of the things that we can peel back. And now, as I talk about this veneer getting thinner and thinner, somebody has sent me Law and Order Special Victims Unit is now putting out episodes on this very issue, and they just put out an episode where they charged a child abuse pediatrician with perjury because she did a medical exam and hid it, which would have been exculpatory evidence to the parents, but she hid it, and they actually came in and charged her with perjury. So we're shoving this veneer to be really, really super thin, and we need to just keep poking holes in it.
Let me look. Please send me a link to that Law and Order episode. I don't watch TV generally, but I'd like to see that. And the other thing, the cases that you're telling us about, I'd like to have them, John will put up some show notes. I'd like to have a link to those cases. And certainly within our group, Freedom Counsel, I want the attorneys to have access to this and be aware of what's happening, because, and I want to get to this later whenever you're ready, John and Connie, but the incentives, there's an incentivization to take children away from parents. So we'll get to that in time here.
Yeah, and I'll tell you, in that area, though, of trying to get a brain trust of attorneys and professionals, there are now a handful of doctors, just like in COVID, actually, where you had just this little contingent of doctors, right, who stepped up and spoke out. In child abuse, there's a little contingent of doctors who will travel anywhere to try to protect families and try to correct the record. There is a listserv, an email listserv called SBS of attorneys, and all we do is pass information about depositions that are occurring, other cases that are coming up. So there's constantly that push, and I would be happy to share that, because we want as many parents protected with a collective brain trust that is seeing what's happening and can share that information.
Well, that is perfect. I think we can expand that brain trust with our group. We have a number of people interested, particularly in family law rights and children's rights. So we are here to help, and I'd love to have a way to help the attorneys know how to get on the listserv to get information. That's critical. That's critical stuff. That's how we started, by the way. We only had a handful of us, and it now has grown to almost 300, by the way, Connie.
Yeah. That's
you know
good.
what I think is, and I was just saying this to someone else, the way I was able to, because I run Magic Feathers org, which is a nonprofit in Georgia, which ostensibly was designed to help bring truth to light and do things like what I've done with helping set up the Free Kindly website, helping the family and their advocates create a rally at the courthouse. These are important things that need to be done, and no one knew how to do it on their end. But what I was talking about to other people was like, this network of people who were trying to bring vaccine injury awareness to the forefront, under great risk, by the way. This network still exists. We still have friends. I was able to make a phone call today to a pediatric psychologist or psychiatrist and just say, hey, is it possible to diagnose someone with Munchausen by proxy without ever speaking to them? And she hit the roof. Absolutely not. That's highly unethical. So these are really
Munchausen by proxy, John, is not something everybody knows. Do you want to explain that to the audience?
Yeah, I mean, you guys maybe have a better term for it, but essentially, it's where a mother harms a child for attention, and it's like a whole thing. It's very rare, very complicated. But essentially that's what it is. And that's what one of the nurse practitioners apparently, without ever meeting her, diagnosed Joy, the mother, with in this case. And then the judge just hears it. How is it possible a judge can hear that diagnosis? Isn't that what they call hearsay?
Yeah.
And not have any actual evidence of a real clinician, psychiatrist sitting down with the mother. Furthermore, well, there's a lot more to it, but essentially, she has two psychiatrists that said that she's does not have Munchausen, and the child should be returned.
Well, with that in mind, I did just recently see that the APA, which is the American Psychological Association, says that they're doing away with the DSM, which is the Diagnostic Statistical Manual, I think is what it is.
Correct.
That they're doing away with the DSM totally.
Great.
Because what the field of psychology has done for, 40 years, all during the term of my trying to practice law, is they take a list of symptoms or a list of observable behaviors or mental thoughts, and then they create a label. Right. And then they put that label on people. And once they put that label on people, they predict, right? They use that label to predict what they may do in the future. I mean,
Minority Report.
There's nothing about it that's scientific at all. So I think there's finally a realization of that. And I attribute that change to the voice of the people.
Yeah. And I mean, I'm going to give a name to this, Connie. And we're hearing more and more about this, the replication crisis. They cannot replicate the studies. Mm-hmm. The studies are not based in anything that's real or hard and fast. You can't replicate them. So we have a huge problem in psychology with the replication crisis, not to mention other fields out there, but certainly psychology is probably right up here at the top. With depression, everything you can think about.
Well, and that was part of the one case that I really invested a lot of time in was what they call a fractured rib case. So there are babies, very, very tiny infants that have multiple rib fractures at various stages of healing. Now, there's never any bruising on the child. There's never a broken rib. There's never internal injuries. But these child abuse pediatricians were coming to court and saying that these parents were crushing these babies one rib at a time over a period of time. And so that's why they showed up at various stages of healing, which just from a logical standpoint to me did not make a lot of sense, right? Like you don't have a single bruise on this baby. And the babies never cry. They're maybe a little fussy once in a while. And so when I located this pediatric radiologist in Illinois, he started sending me tons and tons of research. And he said, Connie, you cannot test this scientifically. He says, it's unethical to crush a baby. You can't crush a baby. And so they would take things like pig fetuses, right, and try to crush a pig fetus or what was the other one, like a sheep or something, and there was no way to replicate it. And so that was part of the testimony that I put on, along with the fact that it was a premature baby. There was low vitamin D. There was other circumstances that could cause extra pressure on the ribs, even during childbirth, that could cause this type of fracturing. But yeah, and shaken baby, you can't replicate either. You can't. And in this Neves case, which I do want you to read through that whole thing, you will find it extremely interesting. But they spent a lot of times talking about, and they talk about, from a lawyer standpoint, they talk about the Daubert test versus the Fry test, and how those kind of fit into this argument. I actually watched the whole oral argument on that as well, which was really good.
And where is the oral argument available? That I love listening to those.
Yeah, so I will send you the case. I believe it's New Jersey Court of Appeals, and I don't think it was a Supreme Court case. I think it's a Court of Appeals case. So I will send you, and once you have the name of the case and the case number, if we can probably together refine that oral argument. It's been probably at least a month and a half ago that they posted that. Yeah. Actually, I think the oral argument occurred in even like almost a year ago, like February or March of last year. And then the opinion, I believe, came out in October or November.
All right.
Oops.
John, you're muted, I think.
Sorry, I just want to, before we transition to your story, because Connie, you have your own shocking story to share. Just if anyone wants to help Kinley get back to her mom, if you would like to, I'm going to try to get this on the screen. If you'd like to learn more about her case, you can go to, it's because I've got the wrong theme. Anyway, freekinley.com. That's going to have refutations of sort of the sham evidence presented by DCF. By the way, the third final social worker that was in the video, the one that laughs, she was, I believe, fired this week, according to some reports. We are waiting for the state to confirm that. So now all three social workers are no longer with DCF. There was a judge that was the original judge, according to the records on the Santa Rosa County Courthouse website. The judge was changed to a new judge a few months ago. I don't know the full details behind that, but sure is interesting when your A-team roster suddenly gets decimated, isn't it?
Yeah, and I would say, I bet you somewhere there's an email for that. I'm sorry, that's in Florida, right? So like in Tennessee, we have this email address, and it's called like DCS customer support or something, .10.gov, whatever. It's ridiculous. But somewhere there's an email. I'm going to highly encourage, if you want to find an email address and put it in the comments or put it in the notes for this production, and people should just send an email. They should email them to death and send an email and say, this is medical kidnapping. You need to free this child. She needs to be back with her mother. I know I did a lot of posting. People started sharing a lot of those. And, some of the comments, for instance, there was a complaint about the medication that she was giving her. But if you watch that whole video, once they get in the house, they ask the mother about her medications, and the mother goes through those medications with meticulous detail and instructs the social workers and the caseworkers on how to care for the child. So it's certainly not as though if truly this were like a mother that was just trying to make up a disease, and she would not tell them anything, because honestly, if somebody's that weird and twisted, they would want the child to die in their custody, right? That's because that would be the whole entire object of their psychopathy, would be a sick child. And so if that sick child died in the custody of the state, it would make them look better, right?
Well, also Munchausen represents with faking illnesses in the child for attention.
Right.
There's no evidence that the mother was able to somehow change the child's DNA to fake a cystic fibrosis diagnosis. I mean, it's so absurd. And let me ask that, to take that further. What in the hell is going on in the courts when a doctor can come in with this kind of garbage diagnosis, or nurse practitioner, and not be challenged and have it fully accepted when it's clearly false? And what kind of, like, I think that if a nurse practitioner or any medical official puts something out there that can be easily disproven, they should immediately go on probation with the state licensing board under a third-party investigation, because as we've all learned, the boards are as corrupt as it gets.
Well, that's what I was telling you with that special victim SVU, Law and Order SVU episode, is where they charge the child abuse pediatrician with perjury for making false statements in the court proceedings that cause those parents to lose their children. So I totally agree. I think that at some point, so the American Academy of Pediatrics, I think it is the AAP, they're controlled by pharmaceutical companies,
Yes.
right?
Yes, they are.
So we're going to have a hard time busting through the AAP. The AAP puts out every year what they call a consent memorandum, consent something. But basically what they're trying to say that they circulate to every single pediatrician across the country is they say, this is what we believe and you should believe it too. Okay. So for instance, with the fractured ribs in 2014, they put out a consensus statement. That's what it's called, consensus statement. They put out a consensus statement and they gave a little bit of explanation of how there could be other medical, other etiology for this, other causes, but they focused on child abuse. And so when the AAP puts out this consensus statement about child abuse, about falling, they put them out all the time, malnourishment, they probably have one on Munchausen's, right? So we're not going to be able to fight it directly through them. We're going to have to build the repertoire of pediatric specialists who know that these are false.
Well, I want to say, first of all, they are being sued right now over a couple of cases. If you haven't heard about them, you will. There were the parents, the young woman's name was Andrea Shaw, and the kids came home with vaccine injuries and died, and they investigated the parents for child abuse. Have you heard of that case?
No.
No, that lawsuit is coming, and that's going to be against the AAP too, by the way. So
Excellent.
There are some things that are happening out there. And I want to make sure that we tell people who are just listening and not viewing the website. It's free, FREEKENLEE.com, freekenlee.com.
Thank you.
And then before we move on, and Connie, I really do want to hear about your story, but really quickly before we move on, could you talk about the incentives that the Child Protective Services in all the states get from the federal government, maybe even from state governments, to take children, remove them from the houses?
Oh boy.
Just quickly, we can do it.
Because I will tell you, my first statement is yes, there is federal funding directly associated with taking children. It's called Title IV-E. And that is where there is a price tag on every child's head to be able to become a hostage of the state government. Okay. And they get federal reimbursements on that. And it makes up 40% of the budget for these state agencies. Okay, this is critical. And then if they can adopt them out to strangers, they will get a bonus check for up to $20,000 per child. The state gets a bonus check, as well as the person who adopts the child continues to get paid for taking care of that child. I call it the secret middle-class welfare program.
And
because
again,
nobody knows about it.
The parallel with COVID is unbelievable. Because you had a benefit, a bonus, if you classified a patient as COVID. The more treatment, the more benefits, the more bonuses, even up to death. And we've got the same thing going in CPA, with the Child Protective Services, and everyone out there who's listening. follow the money. What are the incentives? We're incentivizing some very terrible behavior. And I guess the other thing that I just want to point out, and you probably have seen this too, many of the people working in child protective services are very traumatized by their own childhoods. And then that translates into decision making that does not necessarily match the reality. They're in their own world. They've been traumatized and they are not thinking clearly, frankly.
I'd like to play a quick clip if you guys don't mind. This is something that I found actually on the mother's Facebook page. She's obviously acutely aware of the situation, but I think you'll find it to be interesting.
Court finds that there's a continuing danger to the physical health and safety of this child, and it would be contrary to the welfare to return the child to the parents alone.
Under Title IV-E, what do you train your workers about how the state gets its money in relation to the work they do for your agency? What do you teach them?
For the Title IV-E funding, that's correct, but I don't know about the other grants and all of that stuff.
Okay, the only thing we're talking about right now is the exhibit that's in front of you, Title IV-E funding. In order to qualify for Title IV-E funding, you train your workers that they must remove that child from the home. That's the first step, right?
Yes.
Then the second step you train your workers is that they must obtain from the court an order that says continuation in the home is contrary to the best interest of the child, correct?
Correct.
And you teach them this. If they don't follow those two steps, your agency does not get the money under Title IV-E, correct?
Correct.
So you can see that again if you want at freekenlee.com, Kenlee.
Yeah.
Anyway.
Yeah, but let me tell you, okay, that's only the tip of the iceberg on the money trail. Okay. I just want to put that out there. I'm going to show you this book right here, Injustice Inc. by Daniel Hatcher, who is a professor in Pennsylvania. As much as I know about the money trail, it was jaw-dropping when I read that book. It's a short book. It's only like 150 pages. He has all kinds of endnotes. It's very well resourced. But even Daniel Hatcher misses a huge part, which is very important in Florida, and that's the privatization. Okay? The privatization and the nonprofits who work for, so there's for-profit companies and there's nonprofit companies. And I do a lot of research on, for instance, ProPublica. I look up the nonprofits. I look up their asset gathering, their real property gathering. I look up the for-profits, the contracts with particularly the state of Tennessee. I go to the Tennessee checkbook. I see how much money they're making from the state of Tennessee. I now found out I'm investigating a girls' group home, and the for-profit owner of that group home paid the governor $25,000 out of a PAC he created, and paid a state senator $17,000. So the money is a whole web that we could probably sit and do a whole hour on by itself, which I would happily do with you.
Yeah, it's funny you mentioned that. There's another person that got caught up into that whole pay-to-play situation with children. And everyone may know that her as their favorite state governor, Katie Hobbs in Arizona. She was accused of, her campaign was accused of this. A group home operator essentially made a big donation to her campaign. And then the law changed so that this group home basically got a windfall. And it was for children, Sunshine Residential. According to reports by the Arizona Republic, Sunshine Residential was denied a rate increase in December 2022, but donated $100,000 to Hobbs' campaign. 3 days later, the next year, the increase went up to $234 per day per child, which is higher than the average $169 for other group homes.
Yeah, and that's the other thing that they do. They categorize children just like beef. You have different grades of beef, right? So children are categorized as well. And in Tennessee, the range goes from $29 a day to $651 a day. And there are about 15 grading points in between there. And it doesn't take much for them to upgrade them and upscale them so that they can reward the foster parents with more money.
Well, thank you so much for discussing Joy's case. She's under a gag order, which I don't even know how that's legal. But we have to speak for her. There wasn't much coverage before she was gagged. But Connie, I'd like to talk about your situation in Tennessee, which is also highly egregious actions by government officials. So can you kind of give us the top line of what happened?
Yeah, so I'm going to start with where we are right now. So right now, on March the 19th, 2026, we are going to the Sixth Circuit Federal Court of Appeals in Cincinnati. And I have 2 federal cases pending. This one is going up before the Sixth Circuit panel, which honestly, they don't even give oral arguments to everybody anymore. So it's a big step just that we have that oral argument set and established. And it's all based on a fake crime. And so my client and they have been trying to shut me down for years and years and years. I've spoken, I brought a lot of media to the attention. I've spoken in public forums. I've spoken at political meetings. I've been all across the state of Tennessee in 45 different counties in 4 different states. I started the Family Forward Project on Facebook, which to really just be a forum for hurt parents along the way. We have about 27,000 members, and I ran for judge. I ran for state rep. I mean, I was a constant bear poker, unfortunately. But they finally, in 2019, made up a crime. And I didn't realize at the time that they called me and told me I had been indicted, what had happened. But I had been helping this mom. They went and got a secret removal order for her disabled 12-year-old child. The mother was also disabled. And when they wouldn't call me back, they did this secret order, had a secret hearing. I got very upset. And so I had the mother come to my home a couple counties away. I said, you guys just spend the night here. I'll try to get a hold of the judge. I did not want this mother and child separated. And the next morning, the cops surrounded my home. They had tracked my phone. Instead of giving me the courtesy of a phone call, because they knew she had an attorney, I'd called them, I had left messages. Instead of the courtesy of a phone call, they came and sent the cops to surround my house in a very, in sort of an upper middle class neighborhood. And so I fought them. They took her daughter. I fought them again for about 10 or 11 months, knocked the socks off of them, got the child back. A month later, I got a phone call that my client and I had been indicted. So we turned ourselves in. They chained us to the wall. They put us in booking for hours. She was forced to make a bond. We got out. I got a copy of the indictment. And I honestly, when I saw the indictment, I kind of laughed at it, because what the district attorney had done is she had taken a law that's called custodial interference, and it is a specific intent crime. In other words, it is black letter law. The elements of the crime are written out in the black letter law. And she took out one of the elements of the crime. Custodial interference was written to protect divorced parents when they don't follow visitation orders. And it specifically says when a parent doesn't return a child after the end of visitation in violation of a court order, it's custodial interference. Well, what the district attorney had done is she had just erased all of the language about a visitation order, because it wasn't a visitation order. She erased all of that so that it just said that you detained a child in violation of a court order. And when I saw it, I was like, we'll get this dismissed. This is no problem at all. We'll go get an attorney. I'll file a motion to dismiss. I got her the public defender. I got an attorney. We filed a motion to dismiss the indictment. And the judge, instead of following the law, went along with the scam and rewrote the jury instructions to remove that element of the crime and sent us both to trial. And she had a trial in 2021. She was found guilty. They then extorted her and basically threatened to throw her in jail unless she testified against me. And so, 6 months later, I went to trial, and her daughter took the stand and testified against me. And I got convicted of a felony accessory after the fact of a felony. So They stripped my license away from me immediately. I got a fax from the Tennessee Supreme Court and says your license has been suspended because you're a convicted felon. And I had to go through sentencing. I mean, then when they couldn't get me in jail, they indicted me on another felony to try. They were going to kill me in jail. I have no doubt, because they wanted me in jail at least for 30 days where they could either starve me or poison me. And then they were unable to accomplish that. So we appealed those decisions, or we appealed and we won. The Court of Criminal Appeals agreed that there was no crime because they had rewritten the law. And at the time that occurred, and I kept telling my fellow associates that the judge rewrote the law, nobody believed me. Everybody was like, Connie, judges can't rewrite the law. And I was like, the judge rewrote the law. Well, the Court of Criminal Appeals agreed. The judge had rewritten the law and they reversed those convictions, but it took until 2024 until mine was reversed. So in 2024, just a couple months later, we filed a federal malicious prosecution lawsuit against the 2 district attorneys, the 2 cops, and the DCS attorney. This DCS civil attorney is the one who actually initiated those charges. So there was never a crime. They all got together, they put their heads together, they decided what they were going to do, and every single one of them had to cooperate with the plan. Because if anyone would have said, I'm not going to go along with this, this is not a crime, then the whole thing would have fallen apart. They all made up their mind to proceed. And I had laid out in the lawsuit, like, all the actions that they took, and in emails that, oh, she's going to be indicted before it was ever, the grand jury, months before the grand jury. So we were in the district court, and we had Judge Trauger in the district court, and everybody, if you file a federal lawsuit, everybody, of course, tries to dismiss it on what's called a Rule 12 motion to dismiss, failure to state a claim, or immunity. And so she wrote this very long opinion, like a 70-page opinion. And at the end, the very last paragraph, she says she agrees there was no crime, that all these state actors wanted it to be a crime, but it was not a crime. And then she gave him immunity. So that is what we appealed to the Sixth Circuit. So here, this is going to be a precedental case, whether I win or lose. So the Sixth Circuit is going to be faced with this predicament and this precedent to set. We argue, number one, if there is no crime, there's no probable cause. Okay, so one of the elements of malicious prosecution is there's no probable cause. Even though they got the grand jury to indict us, they got the grand jury to indict us on something that was not a crime. So we're arguing, number one, there's no crime, there's no probable cause. Now, if there's no crime, do all of these people, the district attorneys, law enforcement, do they have any authority at all? If it's not a crime, does the district attorney even have constitutional or statutory authority? And we say no, because the statute, black letter law, is very clear, and it says the district attorney has the authority to prosecute crimes. So for all the lay people out there, sometimes I talk a lot of law talk and I want to dumb it down. Black letter law means what it says. It means it's written down in black letters, and whatever the black letter law says is the law. So when I say black letter law, I mean it's written in the statute or it's written in the Constitution. So the Tennessee statute says the district attorney has the authority to prosecute crime. So we're saying if they don't have that authority, they have no immunity. And we're saying the same thing about the law enforcement. This one captain of investigations had the strict duty to ensure that proper charges were brought against a criminal defendant. That was his whole entire job. Of the 5 defendants, 4 of them are licensed attorneys. So they have no excuse to not understand what black letter law means. So that is our argument. So number one, there was no crime, there can be no probable cause. Number 2, they don't even have authority, therefore they cannot have immunity. Number 3 is conspiracy. The district court did not find conspiracy, but we very carefully laid out each action that each person had to do to make this happen. And so then after those three arguments, we bring up that you can't have absolute immunity if you're not acting in a capacity that is intimately associated with the judicial process. Those are the key words. And then with the there's a little bit of case law out there about, you can go back and you can find tons of cases about law enforcement officers that fabricate evidence. And it's clear a police officer cannot fabricate evidence. A police officer cannot fabricate probable cause, but there's not one single case. And I mean, I pay for Lexus. I have Lexus. I can look up any case in the United States. There's not a single case where they have fabricated a crime. So with me, they fabricated a crime. It's going to be a critical holding. If the Sixth Circuit agrees with us, this will be a substantial hallmark for protecting citizens from rogue district attorneys and law enforcement.
Well, let me go into that a little bit. What you're saying is there are no appellate decisions where a fabricated crime came up because there's no probable cause. So this is a fantastic legal issue. I will tell you, I have dealt with fabricated criminal charges, but most of the time the judge recognizes that immediately and gets rid of it. I mean, that's happened every time, in fact, when they've made up an element or added an element or subtracted, like you said, an element in a criminal charge. The judges look at that and they're like, what are you doing? We just filed motions to dismiss, and they're pretty much gone. So
yeah, and an interesting factor. So I was actually a prosecutor a few decades ago. So I'm sort of familiar with that criminal process, even though I didn't practice a lot of criminal defense. But most of the time, charges are brought by warrant, and in Tennessee, you go to a general sessions court. You can have a preliminary hearing to see if the state even has probable cause, right?
Exactly.
And so here, if they would have given us a preliminary hearing, we would have been able to defeat it right then, because we would have been able to point this out that they didn't have probable cause. But the district attorney didn't do that. She went directly to the grand jury and got an indictment. So we were stolen the right to have a preliminary hearing. But no, the judge went absolutely along with it, even though he made some comments that, well, I don't think they have all the elements. And then he turned right around and removed an element from the jury instructions, from the pattern jury instructions.
Can I ask who was the judge?
So that was Judge Joseph Woodruff in Tennessee. And he has a lot of, he has been on he's had a agenda to get rid of me for a long time.
So interesting. So I just want to make sure, any chance we get to really elevate these judges, we should do that.
Yeah, there he is.
Here you go, Judge. Was he elected or not, or appointed?
Yeah, so he was elected in 2014, and the way he got there is a little mysterious. I mean, to go to my prior history is going to take some time, but scroll back up there. I want to show you something, right? A little bit down. Nope. Enlarge it a little bit and go to his previous employment. Okay, right there. You see partner Waller, Lansden, Dortch, and Davis from 1987 to 2014. So he went from University of Alabama and he went into the military. He got his JAG from 1981 to 1987. And then he pops immediately. That's all out primarily of Alabama and in the military. And then he pops into Nashville with Waller. And Waller is a huge political law firm. And and he wasn't even really a litigator. So I truly believe he was selected to be in the position of judge. And I could really get into some players, but there's a lot of detail there. So because as soon as he was elected, I was one of his very first cases when he was on the bench, and he was just mean and nasty. He put sanctions on me. He found my clients guilty with very little evidence. He would do other strange things. He entered an ex parte order one time that told me to go change the locks on my client's gun safe in another case. I mean, I have another other report from him where he ordered the destruction of evidence, not just the safekeeping. in a divorce, which ended up turning into a criminal case where relevant and material evidence was destroyed. I represented a young kid who was in juvenile detention who was sexually assaulted, and there was DNA evidence. And this very same district attorney's office that prosecuted me screwed that case up, brought the wrong charges so that they could not even use the DNA. And this judge refused to let them bring a superseding indictment on that. So he has a long history, and he also is the one who made up the second fake crime on me, which ended up getting dismissed as well.
Who judges the judges? Because holy crap, there's like nobody paying attention to what they're doing.
There isn't. And, I started in about 2008 talking to the state legislators. Our Constitution in Tennessee has a very important clause in it. Under Article 6, it says that the legislature has the authority to remove a judge. They don't have to impeach him. They don't have to go through an impeachment trial. All they have to do is to do a petition for removal and have a joint session, get a 2/3 vote, give the judge 10 days notice, and he's gone. Our legislature has that power. And then our legislature, with pressure from the judicial branch, I'm sure, divested themselves of that authority by creating legislatively a board of judicial conduct, which is judges, so that the judges' complaint on the judges would be judged by the judges before the General Assembly would ever have the opportunity to make a decision as to whether or not to remove them. And of course, they have only done that once, and that was in 1994.
Now, is that what you just sent me? This petition that just got submitted?
Oh, no, Bill. Okay. I am going to spend a minute talking about this bill. So I also still work a lot with state legislation. I'm very politically active with the party. I go around and I speak. I did a presentation on bad bills and dark money. It made a lot of politicians very upset. But I have some very good relationships with a few handful of very conservative patriot politicians. And so I found out in South Dakota, they passed a bill a couple years ago that is basically mandatory reporting for a state employee supervisor to had a duty to report any employment action that was criminal or fraud or theft or embezzlement. And so they passed that law in South Dakota in 2023, I believe. And then in 2024 or 2025, they actually arrested a CPS worker on this legislation where that CPS worker had fabricated information in the records. So I took the South Dakota bill to a favorable legislator here in Tennessee, and he just got it filed. So I'm going to see if I can't garner some support on that, get that filed. And for any CPS worker that makes a fraudulent entry into records, or there's a federal law called 18 U.S.C. 666, which is theft of federal benefits. And if you're in any work within any agency and you cause federal money to be wrongfully administered or distributed, it's a federal crime. So, I think we need to work on some of these cases from a federal level. I would love to see, for instance, a case like Joy's, where there's a wrongful removal and wrongful retention of a child. Who knows how much federal money has been wasted on the Title IV-E money alone.
Yeah. Connie, we're approaching an hour. I think she should be part of Freedom Counsel, Warner. What do I
no, you're in. No question, Connie. If you want to join us, we are welcome to have you. We have a conference generally every year. We'll have one sometime this year.
That'd be great.
I would love to have you come and present. I'm not sure where. We haven't settled on a city yet, but soon we'll have that. And I'd love to give you an opportunity to be either by yourself or on a panel discussing family rights vis-a-vis the courts. And we have a lot of, the gamut, we cover the gamut at these conferences of freedom issues. So We'd love to have you. And I, in fact, this video, I'm going to make sure that our freedom counselors get an email about it so they can look at it. What you have done is so courageous.
Yes.
And your license has been at issue. And we didn't even get into the consequences of that. But I would love to have you back. I mean, there's so many things. The funding issue, maybe we do something focused on the funding issue, John, in the future. But I am just so thrilled to have you on here today.
Yeah, Connie.
And I want to, and Warren, I do want to throw one more thing at you for you to ponder as part of this whole process. So in 2024, the United States Supreme Court did 3 really good opinions. They are called, one is the Jarkizi opinion, one's the Loper opinion, and one's a Fisher opinion.
Yes, yes, yeah, of course.
So you're familiar with
100%. We're operating with those all the time. Yes.
Okay, so let me tell you what I did. And for the public, I'll just say that basically what the United States Supreme Court did is come in and say you cannot use an administrative process to strip somebody of their private rights. Okay, right? You agree with me?
Yes, yes.
Is that pretty much what they said? Okay. So in my case, the Tennessee Supreme Court created its own administrative agency to disbar attorneys. And so I have filed when they try to, they're trying to disbar me through that agency. And I filed a very lengthy memorandum saying, you can't do that. You can't do that anymore under Jarkizi and Loper. And for instance, they have created rules so stringent that I'm not even permitted to be in a location where law is practiced. I cannot even be hired as a paralegal, or the attorney who hires me will be sanctioned. That's how strict they have made this. So I have filed the Jarkizi Loper in 2 different actions, and I'm about to go ahead and file it in federal court. And the Tennessee Supreme Court has ignored that argument and will not rule on it, and it's been filed for well over a year.
Who's representing you at the 6th Circuit, by the way?
So I am working with Larry Crane in Tennessee. He's a great friend of mine, great constitutional attorney. He's taken cases, for instance, we had some other civil rights cases, and I've worked with him on civil rights cases before. So he's a great person to work with.
I would love to be introduced. His name sounds familiar. I'm not sure where it came up to my attention, but I'd love to be introduced or reintroduced to him, please. And your material, John will make sure we've got all the connections.
He's been on some councils related to churches and law. I don't know, that might be.
We have a lot of religious-based litigation.
Yeah.
Yes.
Connie, did you get your license back?
No.
Wait, but you won your case, right?
Yeah.
But they don't return the license?
No.
God.
They filed another petition. They were afraid I was going to get my license back. And so they filed another ex parte petition on me on a Facebook post where I gave the questionable background of the Supreme Court's attorney that was prosecuting me. And they filed an ex parte petition to keep me suspended, saying I was a substantial threat to society.
Their society, maybe.
Connie, you have
secret society.
Yeah.
Connie, I want to ask you something. You have such a bright and engaging personality, despite all that you've been through. Please tell us how you manage under all of the stress.
Well, I'm going to just be very honest with you. It's not my battle. It's God's battle.
Yes.
You know, I had to.
I knew it.
Yeah.
I knew it.
I could not do this. And it wouldn't be worth it to me to do it on my own, right?
Yeah.
Why? I have no reason. Like, I have a very comfortable life now, and I'm unemployed, and I could have been employed for, another 10 years or so probably. So it's God's battle, and I just wake up every day and say, you just give me who you want me to talk to, send me where you want me to go, and I will continue to do that. So
yes. I very much share that in some experiences that I've had. So thank you so much for that. I think we all need to have hope And you're like I said, you're so engaging, you're so positive. It's just you're a bright light in my day. Thank you.
Thank you. Thank you.
All right. Well, that does it for today. Thanks everyone for watching. I'm going to try to run one more Freedom Council promo. Let's see how well I do.
Okay.
Maybe I'll do a good job. Maybe I will do a good job. Goodbye, everybody.
I believe in the Constitution. I believe that one case, the right case, can change the world. If you believe this too, Freedom Counsel is for you. Pursuing a major case can be overwhelming, but we provide a community of practice so that you have the resources available to support your case. My name is Warner Mendenhall, and we are Freedom Counsel. Join Freedom Counsel today. freedomcounsel.org.